And we're back on the stage. Next to me is Renate. She's a lawyer working at WBS Legal, and she's talking about a very, very up-to-date and crucial and also a little bit creepy topic, artificial intelligence, and especially the legal side of this new feature and the future, definitely. Yeah. So I'm pretty curious how your talk is going to be. And
me too.
I would just say the stage is yours.
Thank you very much. Yes, hello everybody. Artificial intelligence, ChatGPT, I think these are the impressions which are, let's say, the hot shit in these days. Because if you look at in the newspapers or in the TV, there's every day there's something about artificial intelligence and about ChatGPT. It's a nice thing to have ChatGPT, and I will show you why. But there are also a lot of legal issues going along with it, and I want to invite you to accompany me on a little journey through legal questions concerning artificial intelligence. So, my topics for the next 30 minutes are those you can see here. And first of all, I want to invite you to a little chat with ChatGPT because, it's ChatGPT, so you have to try it and go in a little chat. So my first question was, hi ChatGPT, I am giving a talk on the Indie Game Festival about AI, artificial intelligence, and tell the audience about you. And so my first question was, is ChatGPT competent? Does ChatGPT know anything about video games? So I asked ChatGPT, do you play games? And here's the answer. So, it was clear that ChatGPT does not play games, but ChatGPT offered me to go on a talk with ChatGPT and ask some questions. So I thought, okay, great, challenge accepted. And I asked the next question. Can you tell me some games which use already artificial intelligence? And this was very bingo. Within, I think, 10 seconds, ChatGPT gives me the answer about quite a number of games that use artificial intelligence already in various ways. Okay, then I said, good. So let's try the next question. And the next question, which is also the topic today in my talk, how can artificial intelligence be used in video games? And already, again, within, I think, 15 seconds, I had a bunch of points how artificial intelligence can be used in video games. And so at that point I thought, okay, well, now I could ask ChatGPT, can you make me a PowerPoint presentation for this talk? But I thought, okay, maybe I should do this individually. And I began just, myself began constructing that presentation. And now I want to, invite you to go a little bit deeper in the whole thing, and especially into the legal issues concerning artificial intelligence. It's not a new thing. Probably a lot of you already know that we are not talking about artificial intelligence since yesterday. If you go to history, we have the beginnings, I think, at 1950, 1960, something like that. Already in 1990, there was the role-playing Dragon Quest IV, which introduced a tactic system that allowed the user to adjust the IE routines of non-player characters during combat. Though it's really not a new thing, artificial intelligence used in games. When you talk about the history, another quite, I already remember the articles at that time about Deep Blue, who was the first computer to beat the chess champion Garry Kasparov. So you see, there's already some history in concerning artificial intelligence used in games. Where are we now? I mean, a lot of things happened since then, and let me show you some examples. So RE can be used for creating non-player characters in order to enhance the gaming experience. Let's say RE in that point is just controlling or RE is just checking how the user performs, and RE then works with those data in order to adapt the game play to the user. Another thing is that RE can create content. Then you have the possibility that RE can collect a lot of data concerning the user behaviors, and thus in this way RE can also help to improve the game. And of course, as we heard, RE can also be used for game testing and quality assurance. So there are, and this is, let's say, these are four, let's say, more or less main points, but there are other points and projects where artificial intelligence can be used for in games, and maybe make our life easier, but also a little bit complicated. So what are the main legal issues concerning artificial intelligence? And these points should be taken into account when we deal with artificial intelligence. So the first thing is, of course, the copyright thing, which is highly discussed, and we will have a closer look to that. Then, of course, we have the data protection issue. I mean, data protection issue is everything always around. And there's another, let's say, interesting point I want to draw your attention to. This has to do with publisher contracts and concerning also your obligations concerning the source code. Copyright. So that's really, I think, I would say, one of the main legal issues when it comes to artificial intelligence. And then I continued my chat with ChatGPT, and I asked ChatGPT, what are the legal issues when using artificial intelligence in video games? And I was really surprised. I mean, ChatGPT is really intelligent because the answer was, as you can read here, that you can use in artificial intelligence programs, the character design, you can use copyrighted work, and that use of copyrighted work might infringe intellectual property. So that's the answer of ChatGPT, and I would say, bingo, you are right. But what are the legal basics for that? What's the legal, how can I say, the phrases or the provisions behind that? And now it's getting a little bit more legal. One question is, with respect to artificial intelligence, can you use copyrighted templates for the IE learning, for example? Can you feed the artificial intelligence with copyrighted, let's say, books, films, and also can you feed your artificial intelligence program, for example, with source code, with your programming code in order to make it better? Can you say, I have this source code, I give it to the RE, and I say, find me the mistakes, find me the bugs, or add something else to it. And also, source code is protected by copyright. Under German law, source code is protected by copyright. So you would feed the IE program with copyrighted work. And the question is that okay? Can you just take something which is copyrighted, which is owned by an author, and give it to the IE, and the IE makes something out of it? So that's the question. And normally I would say no, because if you use something which is copyrighted, for anything else, it's a multiplication, and that is due to the permission of the author. But we have the German Copyright Act, and concerning that paragraph, which is noted there, it's allowed to do that. It's data mining, and this is allowed according to the German Copyright Act under two conditions. The first condition is that the content has to be free accessible, which means if the content is protected by technical measures, then you can't use the content. But if it's not protected, then you can use the content for feeding the IE. Second condition is that the author has not declared a reservation of use in order to exclude his work from data mining. That's written in the Copyright Act. If the author has made such a reservation, then you are also not allowed to use his work for data mining purposes. But if those conditions are fulfilled, then you can use the works for data mining. That's an interesting result at this point, I would say. Then we would say, okay, the feeding of artificial intelligence with copyrighted work is possible. Nevertheless, the question is, can artificial intelligence infringe copyrights? And so I thought I asked ChatGPT, because ChatGPT is an IE, so she should know, or he, or it, we don't know. Then the answer was, I don't have the ability to infringe copyrights on my own. And you should always respect copyright. It might be possible that copyright is infringed by IE. Okay. Then I thought that I will show you on which ways IE may infringe copyrights. As I said, the feeding is okay under certain conditions. Then there's an output. So you have fed your artificial intelligence program with something, with a copyrighted work, and then there's an output. So the question is, what about that output? Can that output be used in a free way, or does that output infringe copyright? Now, the thing is, as I said, the feeding is okay, then there's the output. The output is not a work. Under German law, a copyrighted work is a work if it's created by a person, by a human being. And artificial intelligence is not a human being. So the output is not a work. So in this context, you are still fine. But if the work is similar to a copyrighted work, let's say, you can see here the Rembrandt, which is not a good example because Rembrandt is already dead, but let's say if it would a copyrighted work, and then you would publish that copy, let's say it would be Andy Warhol, which is still copyrighted, if you would publish a picture which is similar to Andy Warhol in TV, in the internet, then that publication act would be an infringement of copyright. So if you maybe if you would publish your source code somewhere, then it might be that would be an infringement of copyrights. Next main questions concerning artificial intelligence is, who owns the results? Who owns the output of artificial intelligence? Is it the developer? Is it the AI itself, or the user? So according to German law, we would say the developer is not the owner. He just is the one who programs the artificial intelligence program, but he is not the owner of the output. The artificial intelligence himself is also not the owner, because the owner of a copyrighted work has to be somehow an individual person. And as I said, artificial intelligence is not an individual person. It can't be the owner of a work. The user who gives certain commands to the artificial intelligence program is also not the owner. So under German law right now, we must say nobody owns the output of an artificial intelligence program. There might be terms and conditions of the one who offered the AI, like here OpenAI, and they might regulate in their terms and conditions that you are not allowed to use the output. So this would be the only way to restrict the usage. But OpenAI, for example, says in his terms and conditions, you can use the output for everything you want, for anything you want. You can also use it commercially. If you look in other countries like Great Britain or New Zealand, they have regulated the questions of who owns the work in another way. But in England, for example, authorship of the developer could exist, but under German law, we are still not there. So this might change, we'll see, but so far it's not the case. So these are the main issues concerning copyright. Next issue, as I said, is the issue of data protection. If you have an artificial intelligence program which collects personal data of the player in order to evaluate his performance, in order to then improve the gameplay, for example, then this usage of the collecting and the usage of the personal data has to be compliant with the GDPR. And that means you have to be transparent. What are you doing with the personal data? You have to inform the user about the purpose of the collecting of the data. And certainly you need a legal basis, which will be the content, so the consent of the user. So if you collect personal data within a game and with the KI, then there has to be a consent of the user beforehand that he is okay with it. So that's another issue, and it's as the conditions of the GDPR are very high. I think it's a really challenge to put data, the collecting of personal data on a real good and legal basis. Then next interesting issue is contracts. In publisher contracts, you usually or often find the provision that you have to hand out this source code. And the source code has to be handed out in an understandable, written, bug-free form. And now the problem is, if the source code is, let's say, partly written by an artificial intelligence program, and it's not fully understandable, and you are not maybe able to discover bugs in that part of source code which is written by the artificial intelligence program. And as you are maybe not able to discover those bugs, you risk to breach your contractual obligations. So, I am continuing my chat with ChatGPT. And big questions is also the liability. Who is liable for damages caused by AI? So I asked, who is liable for you? And there was no answer. Okay, so I thought, now I'm on my own, and I have to check on my own who is liable for artificial intelligence. In principle, you can say it can be the manufacturer, the supplier, owner, operator, or the programmer. But honestly, yet there are no specific regulations. The reason is the liability for damages under German law affords that there's a fault, so you have to be responsible for that for the damage. And if there's an artificial intelligence program which is just running on itself, then you can hardly find some, let's say, fault or responsibility for the running of the program. We have in Germany an act or a law, which in German it's called the Produktionshaftungsgesetz. And it is discussed whether this law applies to liability for artificial intelligence. So, but it's still open. It might be that the European government and that on the European basis there will be established something like a Produkthaftungsgesetz, but it's still discussed. As you see, a lot of things are still open concerning liability. In Germany, you have the General Eco Treatment Act, which is applicable, which means that that differentiations based on personal data which are discriminatory are not allowed. So this applies, but this actually I think is the only law which is really applicable to the questions liability of artificial intelligence. Yeah, and then EU plans regulations on liability, so we will see where we will go in that respect. Everything is, let's say, open and in development. And as we have heard in the beginning, artificial intelligence it helps, it's good, but it also, some people are afraid of artificial intelligence because, of course, there are dangers concerning artificial intelligence. For example, if it's also about how is the artificial intelligence trained? Is it trained in a good way? Is it maybe it can be misused, and that's the reason why the EU now tries to establish an Artificial Intelligence Act in order to regulate the use and also the development of artificial intelligence. So what's the content of that Artificial Intelligence Act? The interesting thing is that it should apply on all AI systems impacting the EU, but AI systems for military purposes will be not regulated. So this is another thing. It will be not regulated in the Artificial Intelligence Act. the act will differentiate in, let's say, 4 group of risks, and an IE will be categorized under those 4 groups. So the first group is if an IE is regarded as unacceptable, it's prohibited. If an IE has a high risk, there will be severe restrictions. If an IE has just limited risk, there will be few requirements. And if an IE is regarded as minimal, then there will be no restrictions. So this will be the categorizations of artificial intelligence. Yeah. Whether ChatGPT, in which categorization ChatGPT will, or which categorization ChatGPT will have, we don't know, but likely maybe it's regarded as a high risk system because it's very human being-like. If you regard or if you evaluate the answers, you don't know whether there's an artificial intelligence behind or whether there is a human being behind. And that's the reason why it might be that ChatGPT is maybe likely regarded as a high risk system. Concerning operators, how could operators meet those requirements? It will really depend on the terms of use and exclude harmful use in the general terms of conditions. So this will be a challenge to draft terms of general terms and conditions in a way that the operators meet the requirements of the Artificial Intelligence Act. Of course, there are no act without sanctions, and the sanctions I just drafted here can be quite high. It reminds me a little bit to the sanctions of the DGPR, where the sanctions are also very high with respect to money and the infringements. So yeah, we'll see where this comes out. My last questions for ChatGPT was, would you like to share a glass of wine with me? And then ChatGPT says that unfortunately that I don't have the physical presence and cannot consume food. So at this point, at least, we come to the limitations of artificial intelligence, and I said, okay, this challenge I also take, and I would like to share now some, no, not wine with you, but maybe a glass of water with you, and would like to invite you to a discussion concerning ChatGPT or legal issues, because I think a discussion with human beings is still the better choice. So yeah, tell me what you think, what you're thinking about legal issues and artificial intelligence, and what do you think about challenges in video games? Yes.
So one example, if I generate an artwork on Midjourney, you know Midjourney, this art generation site, and if I generate it, I don't have copyrights on it, right? So everybody, if I try to sell it in my game, for example, everybody can take this image and just copy it, and I don't have any legal actions I can take against that. Did I understand that right?
If the result is generated by artificial intelligence program.
Yes.
Yes.
So I can use it. I think I read I can use it to like for commercial purposes, but I don't have any rights on it, like copyright. So everybody can reuse it and copy it for their own game, for example, and I just can look after that. What if, like, let's say it's some kind of money laundering for AI art? if I buy this artwork by a person, but I don't know this person generated it by Midjourney. So in my case, I bought it and I bought the copyright from that person. And then I will actually use it in my game, and somebody wants to copy this image, and I can say, no, I bought the copyright of it, you can't do that. So does the legal system actually have to trace back the whole thing? So asking me, where did you get that image from? They say, from this guy, and they have to track him down and figure out where he got it from, or did he painted it by himself? I don't know. How will they check that? Will they say, send us the PSD file from Photoshop and shows the layers of it, or well?
I can give you an example. There was I think there was a legal case. It's not long ago with Getty Images. And there was a person who used a photo from Getty Images within a artificial intelligence program, and then Getty Images that infringes my copyright. And in the end, the judge said, yes, that you are right, because the photo had a waterproof sign. So everybody could see that that photo is protected. And as I said, under German law, the data mining is okay unless there are no technical measures which show that you are not allowed to use that photo. So and that, if you buy that photo, for example, from Getty Images, and you publish the photo on your website, and you make a waterproof sign, then everybody can see that that's a protected photo, and so I wouldn't be allowed to use that photo in a data mining process according to German law. Whether the problem is, and you are right, how can people find out that I use that photo, and how can people find out whether that's a correct, whether in the end the output is based on a photo which is used for the AI, but how can somebody realize that that output is just based on that copyrighted photo? So that's hard to discover and to find out.
The thing is, I mean, there are actually mechanisms to identify an image is being generated. I mean, in the future, I think those will be gone for some reason or way. But what I mean is, like, even though they can't see that image is AI generated, but I'm saying, okay, but I didn't generate it, I just bought it from someone who acted as a real illustrator, because I couldn't, like, figure out the differences. So how am I protected by this somehow? Or is it like bad luck? Like, yeah, you fell for a scam, and we know it's generated. You bought it from someone. Bad luck. You don't have any copyright.
No.
You know what I mean?
Yeah. If you buy a photo, you are the owner. Just you are the the owner, yes. But to have the copyright position, you have also buy all rights. So these are two different things. So let's say you have all rights, and if you let's say if there's no, let's say you have published your photo on your website and you have no protection on it. For example, no waterproof or something like that. And if you don't have that precondition, or that the reservation of right, which I was talking about, if you have no reservation of right and the third person takes your photo and puts it into the AI program, then under German law that would be okay, and you can't do anything against.
Okay.
I think that he asked more about gutgläubiger Erwerb.
Which,
So when I buy something, how do I know that this one, the artist really owns the copyrights to sell me?
Is about your question?
Yeah.
Oh, okay. Yeah, that's one of the main questions concerning chain of title. Under German law, and I'm pretty sure it's also under Anglo-Saxon law the same, that if you use work which you don't own, you buy copyrights, then you have to check whether the one who sells the copyright is the real owner. That's hard, yeah.
In another country, I can just make
yeah.
up someone,
yeah.
just to launder my artwork through that fictional person, so to say. And that's it, in my opinion, for now. Maybe there will be restrictions, but yeah.
Yeah. Yeah. Well, but
is it similar to a Gutgläubiger Werk?
Yeah, but there is under German law there is no judges and jurisdiction. Also, law doesn't accept a Gutgläubiger verb of copyright. You have also check whether the one who owns. You should check. I know that often it's impossible, but that's the theory, that you have to check whether the one who sells his copyright is the real owner of the copyright.
I think I listened to your masterclass when you that you give in Game Dev Saar once about also copyright restrictions, and
Did I?
and you told that when you go to have a contract with publishers, so you also have to guarantee you own all rights,
That's
and
right.
therefore if you buy something from a freelancer, he also needs to declare you all rights. Maybe you can make a buying contract with the artist, where you buy the artwork. So the artist have to guarantee you have all the rights, and then you can show, oh, I have the rights, and then I have the rights.
That's yeah. No, the risk of liability which you always have if you are not the originator, so you buy third-party works, and you have always the risk that the third party doesn't own the rights. That's the system. So the way to minimize the risk, you will never avoid that risk, because maybe the chain of title there are 10 persons and you won't go the long way. It's impossible. But to minimize the risk, you always, and that's my recommendation, you put a clause in your contracts where the rights holder guarantees that he has all rights, and in case he infringes the guarantee, that he holds yourself or you harmless from any claims by third parties. So you can, if there's a lack of chain and title, you can go back to him and tell him, so now you breached the contract, you guaranteed me the rights, and now you have to pay for any damages stemming from that breach of contract.
So maybe I could ask for Schadensersatz if I bought artwork and anyone else also uses the artwork because it's actually not copyrighted, because it's AI generated, and then of course the buying contract wouldn't be guilty. Because he can't guarantee me the copyrights.
I didn't know whether I get your point.
So I want to buy an artwork.
Yes.
And I also want to own the copyrights.
Yes.
The artwork can't guarantee me actually the copyrights, but he says so. And then when I see, oh, somebody else uses my artwork, but I should have the copyrights, what's about maybe Schadensersatz? Can I claim this?
Yeah, if if you have the rights and somebody else uses your copyrighted work, then you have should stop this usage, and then this can also be combined with the claim for damages.